Hello and welcome to this recorded webinar where I am talking to barrister Justin Bates about the Court of Appeal decision in the right to rent legislation. Justin is a barrister. He's at Landmark Chambers and he specialises in housing, property and local government law. Welcome, Justin.
Hi, thanks for having me.
So, where do we start? I think perhaps if we start with talking about the background to this case. What is the right to rent scheme and how does it work?
Right. You need to go back to those long forgotten days when David Cameron was our Prime Minister and when you could go for a walk on the street without worrying about the police arresting you. You go back to about 2012 and the government of the day had two related policy drivers they were trying to push through. One was the beginning of what we now call the hostile environment, and I'm sure everyone listening to this remembers the press coverage of vans driving round bits of London and bits of the West Midlands saying, if you're not here legally, go home. And the other was a policy driver, slightly more acceptable policy driver to my mind, to try and deal with the bottom end of the residential property market. And David Cameron gave a series of speeches in which he was identifying a problem that people at the lowest end of the residential rented sector, generally those who had precarious rights to be here, found themselves being exploited by a criminal class of landlord. And what he wanted to do was align immigration control and align immigration restrictions so as to encourage those people to leave the UK and target that criminal undersection of landlordism. Now that was the policy ambition. That's not quite what happened when it got to Parliament. So you go to the Immigration Act of 2014 to find out what the right to rent is. And the way it works is that if I just jump ahead a slide here to give you some of the backgrounds to it. The Immigration Act of 2014 and 2016 create these three categories of person that you need to think about. One is the person with the right to rent, which is UK nationals and others who are lawfully present. The second is people who've got a limited right to rent, so people who are here and their visa only lets them be here for a certain period of time. And then thirdly, those who've got no right to rent, which in very simple terms means they're not lawfully present. So all of the British passport holders listening to this will be amused to discover that in the 2014 Act they were gifted this brand new right called the right to rent. The way it works then is not by focusing on those individuals, slightly unusually, having created these three categories of individual. The legislation then focuses on who the landlord is and what the landlord is doing. So what it does is it says that if you are a landlord under a residential tenancy agreement, which by the way includes a license, then you mustn't rent a property to someone who doesn't have a right to rent. And more than that, you mustn't allow any adult who doesn't have a right to rent to occupy the property. So it creates these categories, and then it says to landlords, right, it's your job to know which of these categories your tenant falls into. The way it imposes that obligation on the landlord is to say that the landlord has to make reasonable inquiries about the immigration status before they enter into the tenancy agreement, or in the case of someone with a time-limited right to rent, they have to do it when the time-limited right to rent is... They have to do it initially and then do it when the time-limited right to rent runs out. If you don't do these things and don't do your checks, then a series of very, very bad things can happen to you going on there. Initially, it was just the first one on that slide I put up. Initially, you just got a civil penalty imposed upon you. I say just, it is £3,000 per contravention. So you could have had 4 unauthorised people, which could have been 4 civil penalties of £3,000. So it could be quite a lot of money. But then in 2016, they expanded it to create a criminal offence punishable by up to 5 years imprisonment if you let to someone who didn't have a right to rent, or otherwise authorised an occupier who didn't have a right to rent. And then what they also did is they tied it into possession proceedings. So what's supposed to happen is that you as a landlord do your right to rent check at the beginning. You discover they have a right to rent, tick, fine. If you discover they don't have a right to rent, but you let to them anyway, then you risk the civil penalty or the criminal offence. If you let to them thinking they had a right to rent, but it transpires that they didn't really have a right to rent, e.g. there was a forged document or you just made a good faith mistake, then the Secretary of State serves a notice on you when the Secretary of State discovers that you have this person without a right to rent. And in response to that notice, you need to bring possession proceedings. Because if you don't respond to the notice with possession proceedings, you effectively commit another criminal offence.
Fairly stringent then.
I mean, it's incredibly difficult. I mean, we'll talk about the intervention and my client's position in the intervention in the moment. But that's just the immigration legislation. I mean, so the landlord A has to know how immigration legislation works. B, if it's a limited right to rent, he's got to keep checking it, and not just each individual who's on the tenancy agreement, but any other occupier.
Which is difficult because the landlord can't stand in front of the door all the time, stopping people who haven't got a right to rent going in.
No, quite. And there's also, I mean, we didn't get into this in the case law, although I did try. Sorry, in the case, although I did try to interest people in it. There's also a real problem as to what happens if someone is under 18 and doesn't have a right to rent, but then turns 18 during the course of the tenancy, because you ignore them when they're under 18, but you have to take them into account once they turn over 18. So you could have a situation where someone's child is the flip that turns it over. So I say, not only has he got to do the immigration stuff, not only has he got to do the continued checking, but then he's got to make sure that he's got processes in place to evict someone who the Secretary of State has told him doesn't have a right to rent, even if he thinks his tenant does have a right to rent, even if he's done the checks and he thinks the tenant does have a right to rent. If the Secretary of State tells you otherwise, you still have to take action. And we'll talk about the High Court case. Don't let me forget to tell you about this in the High Court case, because in the High Court, our case is heard with another case called Goloshvili. And Goloshvili is particularly important because that's what had happened. Everyone thought that Miss Goloshvili didn't have a right to rent, and then it turns out she did. So the Secretary of State had served this notice requiring the landlord to start possession proceedings, when in fact Miss Goloshvili was perfectly entitled to be in the country.
Yeah.
So anyway, we'll come back to that. So that's an overview of how the 2014 Act works. As I say, obligation on landlord, remarkably, not obligation on tenant, and sanctions on landlord going from civil penalty to criminal prosecution and possibly even possession proceedings. But you don't just stop with the 2014 Act and 2016 Act, because that would be far too simple. You also have to know about how this ties in with the rest of the regulatory environment. So, for example, a conviction for breaking the right to rent scheme puts you on the rogue landlord database. It's grounds for making a banning order. It's probably ground for refusing or revoking an HMO licence or a Part 3 licence for those who are listening who've got selective licensing areas. So getting this wrong isn't just a slap on the wrist for a landlord, letter from the Secretary of State saying please don't do it again. Potentially it's the complete end of their ability to be a landlord. Now I appreciate the chances of someone being prosecuted and going to prison for 5 years on a one-off good faith breach is probably relatively limited. But it is possible. It is conceivable, and it would be lawful for someone to make one mistake, get convicted, go to prison for 5 years, go on the rogue landlord database, get banned from being a landlord, have their Part 2 and Part 3 licenses revoked. And if that wasn't enough, you need to tie it in with how the wider market responds to this, it is, for example, almost inevitably a breach of your buy-to-let mortgage conditions to let to someone who doesn't have a right to rent. And if the Secretary of State serves the notice on you telling you to evict your tenant, if you don't do so, you'd be in breach of your mortgage conditions. Now, again, query how many buy-to-let mortgage companies would actually call in the mortgage in those circumstances, but they might. So that's why this is such a big deal for landlords, and there are similar provisions for agents. I'm just going to talk about landlords in this talk, because it's easier than having to say landlords and agents. But basically, everything that applies to landlords also applies to agents.
But I mean, even if they don't have the 5 years imprisonment going on the landlord database and all the rest of it, I mean, £3,000 is a lot of money.
Yeah, it's an awful lot of money. I mean, the Secretary of State would say, if you think he's fined you too much money, you can always appeal that to the county court, which is how it works. To which I would say, yeah, but that's just asking landlords to spend even more money to try and deal with the consequences of what could be a perfectly fair and reasonable mistake. Now, it hasn't actually, it has to say, I'm not aware of anyone who's actually been prosecuted for a breach of the right to rent legislation. And there have been some parliamentary questions about the scheme, and it does seem that there haven't been that many civil penalty notices, and the average civil penalty is, I think offhand, it was only about £250. But the fact the Secretary of State doesn't use his full powers is really neither here nor there, because the powers exist. Someone will eventually use them, and no one goes through life thinking, well, if I'm caught, it probably won't be that bad a punishment. People respond to legislation and respond to law by working out what the worst case scenario is, and then and then responding and shaping their behaviour in relation to it. So most landlords know, for example, that the chances of being punished under this legislation is relatively remote. But if they were punished, the sky could fall in. So understandably, the landlords adopt, I would say understandably, landlords adopt a very risk-averse approach. It's not just landlords, I have to say. I know we're not going to go into too much broader stuff here, but there are similar provisions to the right to rent in relation to bank accounts. Banks aren't allowed to open accounts for people who don't have the right to be in the country. There are provisions for employers and such like. There's a whole range of areas where over the last 6-7 years, the policy trend of government has been to co-opt private sector individuals and private sector organisations into helping to police immigration law by exposing those private individuals to potentially draconian consequences if they get something as complicated as immigration law wrong. As you may have gathered from that introduction, I'm not a big fan of this legislation.
Yes, well, I mean, immigration law isn't easy. I mean, the authorities don't have 100% success rate, I understand. I should say here that we have had slight technical issues with this recording. Justin and I both got cut off. But Justin, where were we?
So I think I just finished explaining that, or ranting perhaps, about why I don't really like this scheme and how its tendrils end up getting into all manner of different things. So not only do landlords have to know their immigration law, but then they have to worry about whether a mistake exposes them to criminal law and the wider regulatory consequences and the wider financial consequences. And I was just about to, before we got rudely interrupted, come on to talk about, well, what does the scheme actually require of you? Which should be the slide that everyone is now looking at.
There is a lot of guidance on the government website which people need to look at.
Yeah, I mean, I'm going to talk a little bit about the guidance a bit later on. I perhaps in keeping with the tone I'm adopting today, I don't really think that much of the guidance, in particular because the government keeps doing non-statutory guidance. There's statutory guidance and non-statutory guidance, and for the non-lawyers who are listening to this, statutory guidance is really important. That's where Parliament has said the Secretary of State must publish guidance about this, and the way the law works is that the way statutory guidance works is that you have to have regard to it, you have to follow it, and generally speaking, if you follow the guidance but it turns out the guidance is wrong, then that's the government's fault, not yours. The problem with non-statutory guidance is it's just what the minister thinks at any given time. It's not the law, and it doesn't really help you interpret the law. So the government's done 2 pieces of non-statutory guidance on right to rent recently. It's done a lot more than 2, but the 2 most recent ones. One was about people who were using e-gates to enter the country. It's a handful of countries where we allow electronic visas, which don't work with the right to rent scheme. And then they did guidance on COVID-19 and the right to rent scheme, purporting to change some of the obligations I'm about to talk about on this slide, which of course non-statutory guidance can't do. The Secretary of State can't, just because he feels like it, change what the requirements are. So yes, there is a lot of stuff out there, and as I say, one of the other things that bugs me about it is just how much there is and how often the government plays with it. But anyway, what are you supposed to do according to the statutory guidance and the law when you've got a right to rent situation? There's a long list of documents that's been published by the government about what you're allowed to look at to tell you whether or not someone has a right to rent. And in broad terms, they fall into 2 categories. You've got, in category 1, in very simple terms, I mean, I'm simplifying enormously, but category 1 is basically government-issued ID cards. So a British passport would be one, a French passport would be another, a Slovak ID card, which I'm sure all listeners are fully familiar with.
Of course.
Absolutely. A Lithuanian driving license, I think, which, I mean, I could draw that from in my sleep. And then the category 2 documents, things like utility bills, letters from people in certain professions to confirm that this person is lawfully in the country, that kind of thing. And you need to see, depending upon what kind of document it is, you need to see at least 1 document. You probably need to see 2. You've then got to take a copy of it and keep that copy somewhere safe. You need to check it's genuine, which is the one I think is particularly difficult, because, all joking aside, I'd be amazed if that many immigration officers know what a Lithuanian passport looks like, let alone how many landlords know what one looks like. And then you've got to do the renewal checks if they've got a time-limited right to rent. So on the face of it, it doesn't look like that much. The difficulty comes, I think, in two ways. One is checking it's genuine and effectively checking that what you've been given is good enough. There is a checking service, and there's various things that are available online. But there's no easy way of just looking at a document and knowing. There isn't, for example, a pictorial representation of every permissible form of ID document. So there isn't. You can't go to the gov.uk website and download a document that shows you what a Lithuanian driving license looks like.
I think they do have some pictures in some of their guidance.
So they have pictures in some. There's a pretty good database actually published by the European Union, but even that hasn't got everything. So there's the first one, and then tied to that, if you've got someone and you don't know about their right to rent status, there's a Home Office phone line you can ring where they promise to get back to you, I think, within 48 hours. The problem, I think, seems to me with that is, you know as well as I do that the PRS, particularly in the southeast, is a very fast-moving sector, and waiting 48 hours to find out if someone's got a right to rent, when you've got someone who just turns up and says, here's my passport, inevitably, the person with the 48-hour wait is going to get treated less favourably. And then I've just added a note at the end there. Of course, you can't charge a fee for doing any of this, because it's not a Schedule 1 Tenant Fees Act permitted payment. So you need to make sure you're not charging anyone for carrying out your right to rent checks. You used to be able to until the Tenant Fees Act came into force. So it doesn't look like a lot when you just do it as 4 bullet points, but in practice, I think this is actually quite difficult. in the context of how the market works, particularly in areas where demand exceeds supply, and in the context of who the private landlord is, and we'll look at this later for the evidence about, I don't mean this in a disrespectful way, but the relatively unsophisticated nature of the private rented sector in this country. It's just a burden that can very easily go wrong, e.g. you're simply mistaken about whether or not this is a Lithuanian passport. In fact, it's a Lithuanian driving license. And it just seems to me to carry an awful lot of obligation and transfer an awful lot of risk onto what the landlord is doing. And that ultimately ties into what actually the case that we're talking about ended up being about. So this is a good time to talk to you about what the case was actually about.
Mm-hmm. So who are JCWI then?
So the JCWI are the Joint Council for the Welfare of Immigrants. They are a long-standing pressure group who exist for the purpose of promoting and protecting the rights of immigrants into this country. And they're pretty well respected. They do a lot of very technical work on immigration law, for example. And they're also very good at bringing to public and government attention some unwanted, undesirable, and perhaps unforeseen consequences of UK law for people who are moving to this country. So they're just called the JCWI, but their full name is the Joint Council for the Welfare of Immigrants. Mm-hmm. Let's just look a bit about them first. So the right to rent scheme, as I'm sure you remember, and anyone who is a landlord in the Midlands will know, ran initially as a trial scheme in December 2014 in the Midlands. As a result of that trial scheme, the JCWI carried out some research, including interviews with landlords. And the JCWI's research concluded that the scheme was causing landlords to discriminate against people with foreign accents, foreign names, and those without a British passport. And just to give you an idea of the scale of the discrimination, 42% of landlords said they were less willing to let to someone who didn't have a British passport, and 27% said they were reluctant to someone who appeared foreign. Now, that's not great, particularly the less willing to rent to someone who appears foreign. The 42% who are not willing to let people without less willing to let someone without a British passport. It's that 42% that's really interesting, because what that 42% had worked out is that if you've got a British passport, then barring some truly bizarre quirk of immigration law, you've almost certainly got a right to rent. So it was, even from the trial scheme, the trial area, landlords had worked out that a British passport was the easiest way to pass through this right to rent legislation. So the JCWI do this test program, or this test survey on the trial area. The Home Office reject the conclusions, and they say that there's no hard evidence of any systematic discrimination towards foreign nationals from letting agents or landlords. And so in February 2016, the whole scheme comes into force in England. The JCWI do further mystery shopper exercises, effectively. Now, I'm not going to go into all the mystery shopper exercises, although in the case law we go into them in huge detail. Effectively, it's people who have the same or equivalent documents trying to get tenancies, but some of them have white Anglo-Saxon names, and some of them have names that sound like they are not associated with the UK. Mm-hmm. So what they're trying to test is, if you haven't got a British passport, what's the impact? Because if British passports are all that landlords are looking for, two people, neither of whom can give it, both should be treated the same way. And that isn't what happens. What happens, according to the evidence, is that if you can find a British passport, you jump through the hoop immediately. If you can't find a British passport, then landlords prefer the person who is white and who seems to be Anglo-Saxon. So what landlords are doing, say the JCWI, is they're using racial and ethnic factors as a proxy for the status of being British, and therefore they are preferring people who they think, rightly or wrongly, pose a lesser degree of risk to them in terms of the right to rent scheme. So the JCWI are saying that the scheme is causing
Hello?
by preferring a British passport.
Could you say
hello?
that bit? Could you say that bit again?
Sorry. So the JCWI say the scheme is causing two things. It's causing landlords to discriminate in favour of someone with a British passport. And of course, you don't need a British passport to have a right to rent. You could have a French passport, or you could have a Swiss passport. That's the first kind of discrimination. And the second kind of discrimination it's causing, they say, is that if you haven't got a British passport, it's favouring white people over other people. So that if you are a black British person and a white British person, and neither of you can show a passport, the white Brit gets the tenancy. And they say that is unlawful discrimination. They say it's caused by the legislation. It's not landlords being inherently racist. It's the legislation causing them to adopt this approach.
Institutional racism.
Well, yeah, kind of. Where this gets really, really interesting from a legal perspective, I mean, the case is fascinating from a number of perspectives, is if they're right, and we'll see in a minute they are, but if they're right, what responsibility does the government have for legislation that doesn't require discrimination? Because nothing on the face of this act requires you to discriminate as a landlord. But if you pass a law that looks like it's neutral, but in practice causes people to discriminate in a way they wouldn't otherwise do, whose fault is that discrimination? Is it the government's, or is it the individual landlords? And that's ultimately what this case ends up being about. So that's the JCWI's scheme, JCWI's challenge, and they bring what's called a judicial review claim, in which they want the High Court to declare that the scheme is causing unlawful discrimination, and they say that's contrary to the rights of prospective tenants under Article 8 of the European Convention on Human Rights, which is the right to respect for your private and family life. They also say it has Equality Act implications, and because the scheme is only in force in England, they want the High Court to say the government can't extend it to Wales and Scotland until it's taken steps to remedy the discrimination. Liberty, the well-known pressure group, intervene to support the JCWI. An intervener, by the way, is someone who doesn't bring the claim, but says that they have some particular expertise or skills they want to bring, which will help the court understand the claim. So Liberty intervene to talk about the human rights position. The Equality and Human Rights Commission intervene to talk about the Equality Act position. And the organisation that was the Residential Landlords Association also intervenes. And that was me. I was acting for the RLA. And we intervened to explain why the right to rent scheme causes landlords to behave in the way that the JCWI's evidence says they behave. And we wanted to make three related points effectively. The first thing we wanted to say is that it's important for the court to understand who the private rented sector actually is. I'm not going to go through all of our evidence, but we did quite a detailed statistical survey showing that the PRS is relatively unsophisticated in England. And that's not a slur on any particular landlord, it's to do with the size of holdings. So 62% of the private rented sector is made up of landlords who own one property. The average portfolio size is 2.7 properties. There's been, I think we said, about 100% increase in lodger landlords over the last few years. So although they're still quite small numerically, the lodger sector is growing enormously. And what we wanted the High Court and the Court of Appeal to understand is you're not dealing with a sector that's got an enormous human resources office in the background. It's not like we are Barclays and you ban Barclays from hiring people who aren't British or who haven't got a right to be in the country. Barclays has all the infrastructure in place to do that. The PRS is effectively small-time landlords who own one property that tops up their pension fund. It's the flat you bought before you got married. It's where you put your retirement income because returns are so bad. We don't have a particularly developed build-to-rent market, and we don't have a lot of institutional players in our PRS. So that was our first point about who is this legislation applying to. And then our second point was to explain to the High Court all the regulatory and financial risks that I talked about earlier. So we took them through the consequences for landlords if they get this wrong in terms of civil penalties, criminal prosecution. We took the High Court through the wider regulatory framework, banning orders and the Rogue Landlord database and such like. And we explained how buy-to-let mortgage conditions worked and what the consequences would be. And what we were doing then is our third point. We were saying, well, look, if you've got a relatively unsophisticated sector that doesn't have back office support, if you've got a sector where if they get this wrong, they could effectively lose their right to be landlords, are you really surprised that they are adopting a low-risk approach? Because that's what this is. It's not that landlords are inherently racist. It's that landlords are concerned about the regulatory impact of this. And so what they do is they say, first person who can prove that they meet the right to rent schemes gets the tenancy. And the quickest way to prove it is to show your British passport. And that's ultimately what the slightly odd coalition of three progressive political organisations and the RLA were saying. And the government's position in the High Court was really to focus on the JCWI and just to say your evidence doesn't show that there's any kind of discrimination. They didn't really engage with what we had to say. I don't think they really understood what we were going on about when we talked about banning orders and the Rogue Landlord database and such like. They were really just arguing that the evidence doesn't show there's discrimination. And the government lost in the High Court. High Court fined for the JCWI. And the High Court judgment is quite long, but we can boil it down to a handful of points. The first, and to my mind the single most important, is that the High Court agrees with the JCWI. The scheme causes landlords to discriminate where they would not otherwise do so. So we don't have an inherently racist landlord sector, says the High Court. What we have is legislation that causes them to adopt a safety-first approach of preferring British passports and then causes them to adopt what may be inaccurate, but they still regard as a safety-first approach of preferring white Anglo-Saxon named people. And the reason for that, said the High Court, the second point, is that when you look at this scheme, I mean, they accepted everything that we had to say in the High Court. When you look at who the PRS is, when you look at the sanctions, when you look at the delays that come with needing to do a right to rent check, and when you look at the risk that comes with a right to rent check, are you at all surprised that landlords do this? So the High Court says that the way landlords are behaving is perfectly explicable and perfectly rational. It's about minimising risk. We then get the third point, and this is the one of general sort of constitutional importance here. The third point is the reason why this case will end up on university students' reading lists. The High Court agrees with the JCWI that it's the government who are responsible for the discrimination. If you pass legislation that, although it looks neutral, has the effect of causing someone to discriminate, then that's your problem, government. You don't get to say we passed the legislation doesn't require anyone to discriminate, we are not responsible for the acts of these landlords, you have to own the consequences of your discrimination. So the government is responsible for the discriminatory response of the private rented sector, such response being the rational response to their legislation. And then in terms of remedy, the JCWI get everything they want. So there are declarations that it violates the rights of prospective tenants under the Human Rights Act, there are declarations about the Equality Act, and the High Court says it would be unlawful to extend the right to rent scheme to Wales and Scotland until the government has worked out what to do about this discrimination. Just pausing there, that's a pretty big deal as a judgment.
It is. I remember when it came out.
So do I. We, as I'm sure you know, but perhaps not everyone listening to this does know, the people in the case get a draft of the judgment normally just a couple of days before it gets handed down, because you're supposed to read it through for typos and corrections or mistakes the judge has made, and then you're supposed to agree a form of order as well. I can remember exactly where I was when I got this come through, and I opened it up on my phone to read it, because all you ever do is you skip straight to the last page to see what the result is, and then you go and read it properly afterwards. I can just remember being amazed with the result that had come out, because we'd had a good hearing, and the judge was a bright, intelligent man. He'd enjoyed the hearing, he'd engaged with it well, but this was a really big deal, and he'd given them everything they wanted. He agreed with everything that the JCWI and the RLA said, and it was a complete and utter victory. Unsurprisingly, the Secretary of State appealed. Because it's not just about the right to rent scheme. I mean, we mentioned earlier, before the technical problems, that you've got similar things to right to rent in employment, in bank accounts, in hospital care, for example. There's a whole range of situations where if you're not lawfully present in the country, people aren't supposed to be able to help you. So it's not only they can't rent to you, they're not supposed to open bank accounts for you, they're not supposed to employ you, etc. So once you get one of those schemes attacked like this, you can immediately see how others will try and use this case to attack other bits of it. So the Secretary of State was obviously going to have to appeal. And he does appeal, and the Court of Appeal have reversed the High Court's decision. But in quite an interesting way, they have accepted that the High Court was right to find that it was the scheme that caused discrimination. So the Secretary of State appealed on everything. He said that it doesn't cause discrimination. If it does cause discrimination, I'm not responsible for it. If I am responsible for it, it's not unlawful discrimination because there's a wider policy objective that I'm trying to achieve, and that policy objective is to prevent unlawful immigration, and you should give my views enormous respect because I'm the Secretary of State, and this was debated in Parliament, etc., etc. So he loses on the causation point in the Court of Appeal. The Court of Appeal say no, the scheme does cause discrimination. It causes landlords who would not otherwise discriminate to discriminate. The difference between the Court of Appeal's decision and the High Court's decision is twofold. They say, one, that discrimination isn't inevitable. It doesn't flow automatically from the legislation. There's still an element of choice by landlords to act in a way that's discriminatory, and the Secretary of State isn't responsible for that individual choice. In any event, they say, you can cut through all of this, because regardless of who's responsible for the discrimination, it's not the case that discrimination is always unlawful. Discrimination can be permitted in law if it's effectively a proportionate way of achieving a legitimate public aim. So, for example, it's okay to discriminate against murderers by locking them up because that's a proportionate way of punishing murderers. It's okay to have. Will be another example. It's okay to have minimum height requirements, let's say, for fighter pilots, because fighter plane cockpits are all built to a certain spec, and you can't be 5'2" and do it because you wouldn't fit.
I think there's height with the police, isn't there?
I think there is height with the police. I think they're similar for the fire service, and there's fitness requirements for the army and such like. So it's not the case that all discrimination is unlawful. Some discrimination is justified, and that's what the Court of Appeal have said. They said although it's discriminatory, this is about immigration policy. Immigration policy is something where the government gets what's called a wide margin of appreciation or a large degree of deference. That depends on the kind of wording you're reading. But basically, it's the courts recognise that some questions are so inherently political that courts are not best placed to decide them, and Parliament should decide them. And that's what they say this is about. They say it's immigration policy. It's about who is allowed to be in this country under what conditions. Parliament decided that this was an appropriate way forward. This act was debated at length in Parliament. It's not for us to interfere in Parliament's policy choice. So any discrimination that there is justified. So that's where it's got to.
Are they saying then that it's okay for human rights to be breached if it follows a debate in Parliament and the passing of an act?
Our law has got pretty close to that. I mean, it depends on the human right in question. So this is what's called Article 8. Article 8 is a qualified right. So you have to have the right to respect for your home, but you are allowed to interfere with that if it's a proportionate means of achieving a legitimate aim. So some human rights can never be violated. Article 2 is the most obvious one, which is the right to life. The government can't pass the Justin Bates brackets mandatory execution close brackets act. It's just not allowed. So Article 2 you can't do. Article 3, which is the one that says you can't torture people, that can't be deviated from either. But most human rights are what's called qualified rights. And so Parliament could decide there are some circumstances in which there is some really important public policy aim that means that it's okay to violate people's rights. And what the court is saying, and it's been saying this for a number of years, particularly in welfare benefits cases, all of the bedroom tax cases, for example, they say, look, where it's about areas of particularly controversial public policy, benefits, immigration, taxation policy, Parliament is just the best place to deal with this. The courts really shouldn't be second guessing. So unless Parliament gets it completely and utterly wrong, sometimes, I don't want to turn this into too much of a constitutional law seminar, but sometimes they say things like, is Parliament's view manifestly without reasonable foundation? Unless Parliament gets it strikingly wrong, the fact that the courts don't like it isn't a good enough reason to interfere. An immigration policy is classically an area where the courts don't really like interfering, because who comes into the country is much better dealt with by politicians than by courts. The politicians should set the rules, the courts should just apply them. So it's not quite if Parliament debates it and passes the law, then you're safe, because it depends on the content of the law. But with a qualified right, the fact that Parliament has debated it is a pretty powerful indication that the court shouldn't be getting involved.
But it seems to me that in most legal arguments that go on to be litigated, it's like there's a line, and where do you draw the line? Whereabouts on that line do you place the marker? Is it at this end or is it at that end? And that's what the court has to do. It has to decide whether this legislation is so unreasonable, which is what the first king was, that it's unlawful, or whether it's something that Parliament can do.
Well, I think that the difference between the two judgments, the High Court and the Court of Appeal, is where they start from. If your readers just want to read the first paragraph of the High Court and the first paragraph of the Court of Appeal, you can immediately see the difference in approach. So in the High Court judge opens by saying, this case is about discrimination. Discrimination is something that is abhorrent in a civilized society, and needs pretty powerful reasons for a court not to say that it shouldn't be allowed. Whereas the Court of Appeal opens with, this case is about immigration policy. Immigration policy is classically something for Parliament rather than for the courts to get involved in. So depending on how you frame this case as to what you think it's about, if you think it's about discrimination, then it's much easier for you to do what the High Court did and say, this legislation is discriminatory. Discrimination is bad. I shall not allow discrimination. If you think it's about immigration policy, then it's much easier to come to the Court of Appeal's conclusion, because you say, well, look, what do 3 Court of Appeal judges know about immigration policy? Policy is for Parliament to decide, and Parliament decided this is the position. And I think that's why this is such an interesting case as a abstract legal concept case, because the two, nothing changed. The evidence didn't change from one hearing to another. It's just the lens from which you view that evidence leads you to 2 different conclusions. And it's one of the reasons, it seems to me, that I think it's pretty likely this case will go up to the Supreme Court for them to have another go at looking at it. Because they're both perfectly defensible legal interpretations to come to. The really big issue, I think, where if I were the Secretary of State I wouldn't be entirely happy, is the Court of Appeal and the High Court both say this is causing discrimination. That's bad. Legislation shouldn't cause people to discriminate. Certainly not in something as important as, do you get a house or not? I mean, if I were we can't do this because the RLA as the intervener hasn't got standing to do this. But if I were an individual tenant trying to find accommodation, I'd be really quite interested in going off to the European Court of Human Rights and saying, look, they've passed a law that causes suppliers, landlords, to discriminate against me. How can that possibly be right or fair? I mean, that's the interesting, the oddity of this case is that there's no individual involved. It's all an argument about statistics and how the market as a whole is responding. I said earlier I'd mention a case that was heard with us in the High Court, a case called Goloshvili. Miss Goloshvili has been in the UK for a very, very long time. She rented a property from her landlord. The Secretary of State decided that Miss Goloshvili didn't have a right to rent, and so served a notice on the landlord requiring him to evict Miss Goloshvili. During the course of those proceedings, it was discovered that Miss Goloshvili did have a right to rent. Some students at Liverpool University doing some pro bono immigration work discovered that actually she did have a right to rent. The Secretary of State had granted her permission to be in the country years ago, just as the letter had never left the Home Office, and so it had never got to her, and she didn't know she was in the country lawfully. I mean, I slightly hammered up for comic effect, but it wasn't that isn't that far from what happened. So it was one of the fun things about the hearing in the High Court, because of course on behalf of the landlord we got to say, well look at the Goloshvili case. The landlord could have done all the right to rent checks you want. I mean, he didn't in Miss Goloshvili's case, but he could have done all the right to rent checks you want. It wouldn't have helped him, because the only person who knew she had a right to rent is the Secretary of State, and the Secretary of State is the one serving the notice saying she doesn't have a right to rent. But someone like Goloshvili, someone who either does have a right to rent but just the Secretary of State hasn't bothered to tell them, or someone who's lawfully present but doesn't have a right to rent, it's quite hard to be one of those people, but it's not impossible. They're being exposed to legislation that has the effect of causing landlords to discriminate against them. I'd be really quite keen, if I were a tenant in those circumstances, to try and take this to the European Court and ask them to look at this, because it's much harder to frame this as being about immigration policy when you've got an individual who is effectively forced to sleep on the streets through no fault of their own. That was where I think that sort of the next round of the litigation will be. For this one, though, this one I think will be going up to the Supreme Court. I think there's some big stuff in here. A, what kind of case is this? B, to what extent is the government responsible for how landlords respond to its discriminatory legislation? I think there's some enormous points in there that will go up. So just sort of coming to what does it mean at the moment? I mean, on the one hand, nothing has changed. The right to rent was still the law even after the High Court. The High Court doesn't have the power, save in truly exceptional cases, to just strike down acts of Parliament. We're not like the Americans. You can't. Courts don't really go around overturning legislation. So the right to rent was still the law even after we won in the High Court, and it's still the law now. And for landlords, their obligations haven't changed. Keep your records, keep up to date with the guidance, as you mentioned earlier. Both the statutory guidance and the other guidance. I mentioned the e-gates and the COVID-19 guidance. And effectively, you need to make sure as a landlord or as an agent that your policy doesn't discriminate. Because if you discriminate, you yourself will get sued. And you really don't want to be on the receiving end of that. So, I mean, on the one hand, nothing has changed. On the other hand, you've now got the Court of Appeal and the High Court saying that this legislation makes landlords discriminate. Landlords who do not want to discriminate feel compelled to do so because of how serious the consequences are if they get it wrong. I mean, that's really uncomfortable for the government, and frankly, without sounding too pompous about this, that should be something we're really uncomfortable about as a society.
What sort of society do we want to be? Do we want to be a society which discriminates against people who, through no fault of their own?
Well, and not only that, uses other individuals as the vehicle for that discrimination. You know, it's one thing for the government to say, I am going to pass a law that discriminates against this group, and I'm going to do that notwithstanding how bad discrimination is, but because I think there's some really important factor that justifies doing it. So I'm going to pass a law that discriminates against
red-headed people.
Red-headed people, let's say. I'm going to discriminate against red-headed people, and the reason I'm going to do that is because it's actually been shown that red-headed people spread COVID-19. And so I'm afraid they all have to be detained because that wider public benefit is so important. It's quite another thing to say, I'm going to pass a law that looks fairly neutral, but actually means that one very powerful, important class of people will discriminate against a weaker class. And landlords are a stronger class than tenants. I know there are probably some people who are gnashing their teeth at this and think tenants' rights goes too far, but broadly as a sector, landlords are a more powerful sector than tenants. They are generally better resourced, and they tend to hold property in a way that tenants don't. That should make you really uncomfortable, that Parliament uses private individuals as a tool for achieving discrimination. I really struggle with that, and that's the broader philosophical question I think the Supreme Court will want to have a look at. Is that really an appropriate use of legislation? Or, as the High Court held, no. Once you know that legislation has the effect of discriminating, do you have to say, I'm sorry, but you need to look at this again? And I think that's going to be the philosophical angle for why this goes up. So we will see. At the moment, the JCWI have to ask the Court of Appeal for permission. I don't think they've done that yet. There's a timetable whereby they ask and Secretary of State responds, etc. Assuming the Court of Appeal say no, and they do normally say no, regardless of how important they think the case is, because they normally take the view that the Supreme Court should decide for itself what it hears. There's an idea in law that the highest courts in the land should always have what they call their own docket control, so they should always be left to decide what they want to hear. So assuming the Court of Appeal say no, I would imagine we'd hear that JCWI will ask the Supreme Court, and I would guess we'd hear about permission probably end of summer, early autumn perhaps.
Mm-hmm.
Hearing this time next year in the Supreme Court.
So we won't know until, I don't know, middle of next year, I suppose.
Yeah, I think that's probably realistic.
So that's the middle of 2021 for people who are listening to this after sometime after the recording.
Some years later, yes. Someone's discovered this in 2025 and has paid their £12 to listen to it. Yeah, I would
probably be another one by then. I'll get you to come and do an update, Justin.
Well, once I get judgment in the gas safety case, you're going to want to do that one as well, aren't you? Yeah, I would have thought so. Mid-2021, I would have thought. So the High Court hearing was December 2019. No, 2018, sorry. Court of Appeal was January 2020. So yeah, it takes about a year to go through each stage. So that feels about right.
Yes, litigation is not a quick process.
Well, no, and particularly not at the moment. You and I were chatting before we started this webinar with COVID-19 meaning all kinds of courts just shutting down. It's going to get even slower, I'm afraid.
Still, it's a very, very interesting case, and it's been very interesting listening to you explaining it.
Thank you. I mean, it's a bit far off the beaten track, I suspect, for most people who were listening to this, because for most people, most landlords and agents, they just comply with the law, regardless of what they think about it. But I do think it's quite an important case, for all the reasons I've given.
What about the fact that the government hasn't really done anything with it? I mean, I'm sure I've read that there haven't actually been many tenants who don't have the right to rent who are actually deported as a result of this. Everybody's been inconvenienced to do all this checking, but it doesn't seem to have achieved very much.
I mean, the High Court thought that was that was a kind of another reason as to why this was a discriminatory legislation, because they said, well, look, it's not doing anything. I mean, you don't impose many fines. You haven't managed to find anyone and deported them as a result. You've just created hassle for people without really doing anything with it. Court of Appeal, though, said, but look, it's immigration policy. We don't get into this. I mean, that there are lots of people who don't get deported. That doesn't mean that we're entitled to go around saying immigration policy is wrong. I think there is a problem with it. I think, again, at a philosophical level, you shouldn't have law that doesn't get enforced. You shouldn't have law to act like some nudge theory to try and just encourage people to be good or to do something or not do something. The whole point of law is that if you don't comply with it, someone should be able to enforce it against you. But the government, how would it work in practice? First, how does the government ever actually find out that you're renting to someone who hasn't got a right to rent? I mean, we don't have... the Home Office doesn't send people to go and knock on landlords' doors and say, could I see your right to rent checks? Secondly, if the Home Office ever does find someone who hasn't got a right to rent, and it serves the notice on the landlord saying, you've got a tenant who hasn't got a right to rent, landlord goes to see his tenant, who presumably, if they really are unlawfully present, will just leave and go and hide somewhere else. I just don't think it works. I think it's another example of laws that are passed to get headlines in newspapers rather than laws that are actually passed to make a difference. But
it's certainly a nasty law. It's a law that encourages discrimination is thoroughly unpleasant. I've always thought.
Well, it's also a law that arises out of the government's own inefficiency. If someone isn't lawfully present in the country, it's the government's job to find them, and it's the government's job to deport them. That's why we have a borders agency. It's not a private individual's job to identify these people and deport them. That's just not the kind of society we live in. And penalising a landlord or an agent because the Home Secretary failed to deport someone just strikes me as the wrong way round here. If the Home Secretary thought that Mr. X had no right to be here, the Home Secretary should have deported him. The fact that the Home Secretary forgot to deport Mr. X, or lost him, or otherwise, managed to mess things up, the Home Secretary should fix that by finding Mr. X and deporting him, not by making landlords go to prison for 5 years if they house Mr. X.
Yeah.
Coming back to where we started, and to wrap this up, I suspect, if you really are worried, as David Cameron said he was at the beginning, about a slum underclass of landlords who prey upon people who are living in the grey economy, by all means take steps to stamp that out. But you do that by creating a particular offence of knowingly assisting someone who has no right to be here, and doing so for your own financial benefit. So in the Court of Appeal in this case, we looked at how all the other European countries deal with this, and lots of countries have done that. They created a criminal offence of assisting an unlawful migrant for your own personal financial gain. Just that we went and said, no, we're not going to target it. We're going to put this new blanket obligation on an entire class, landlords. And we're not going to target it at the slum element. We're just going to say the whole sector has to deal with this. I would have fewer objections to a law that said, if you are one of those people who preys on people who aren't supposed to be in the country, and you charge them hundreds of pounds a week to sleep on a mattress in a shed, that's really what this ties into, then I don't see a problem with the criminal law coming down on you like a ton of bricks because you are exploiting people. That's very different from imposing a regulatory burden on a whole class, where the class isn't the cause of the problem.
Yeah. Well, we'll have to see what the Court of Appeal make of it.
The Court of Appeal hated us and then we lost.
Sorry, the Supreme Court.
Court of Appeal listened very politely for 3 days and then stuck the knife in.
Well, let's see what the Supreme Court do. It's a very interesting case, and the story hasn't ended yet, folks. There's more to come. So it just remains for me to say thank you very much, Justin, for explaining it all to us, and we'll probably be coming back to you in about a year and a half's time when the story has gone a little further.
Yes, I hope so. Thanks for having me.
Thank you.
Cheers. Bye-bye.
Bye-bye.